Companies Act Section 48, Variations of Shareholders' Rights. Section 48 of the Companies Act establishes the legal framework under which the rights attached to shares in different classes within a company may be modified. The provision ensures that shareholders' rights are respected and protected, while also offering a process for variations when agreed upon or required for the company's governance and management. Below is a detailed explanation of the key elements outlined in this section. 1. Conditions for variation of shareholder rights. Classes of shares and variation of rights. When a company's share capital is divided into multiple classes of shares, such as equity shares and preference shares, the rights attached to each class may be subject to modification. These rights can relate to voting powers, dividend entitlements, participation in capital distribution, or other benefits associated with the class of shares. Consent required for variation. The Act stipulates that the rights attached to a particular class of shares may be varied only under one of the following conditions. Written consent from holders. The variation must have the consent of shareholders representing at least 3/4, 75%, of the issued shares in that particular class. The consent must be documented in writing. Special resolution at a class meeting. Alternatively, a special resolution must be passed at a separate meeting of the shareholders of that class. This meeting is conducted exclusively for the holders of the shares whose rights are being varied. 2. Provisions in the memorandum or articles. The ability to vary shareholder rights may depend on the company's internal governance documents. Provision in memorandum or articles of association. If the memorandum or articles of association allow for such variation, the procedure outlined in these documents must be followed. In the absence of explicit provisions. If no specific rules are provided in the company's memorandum or articles, the variation may still proceed, provided it is not prohibited by the terms of issue for that class of shares. 3. Impact on other classes of shareholders. If the modification of rights for one class of shareholders directly affects the rights of another class, the Act ensures that the interests of the other class are also protected. Consent from affected classes. In such a case, the consent of 3/4, 75%, of the shareholders of the affected class must also be obtained. Application of Section 48 provisions. All the requirements and protections outlined in this section will apply to both the original class, whose rights are being varied, and the other affected class of shareholders. 4. Right to challenge variation before the tribunal. If certain shareholders do not agree with the proposed variation, the Act provides them with the option to challenge the change. Threshold for application to the tribunal. If at least 10% of the issued shares of the affected class either did not consent to the variation, or voted against the special resolution for the variation, these shareholders have the legal right to apply to the tribunal to seek cancellation of the variation. Effect of tribunal application. If an application is made to the tribunal, the proposed variation will not take effect unless and until it is confirmed by the tribunal. This ensures that shareholders have a fair opportunity to contest any variation they believe is unjust or improperly decided. 5. Time frame for application to the tribunal. The Act specifies the time within which the shareholders must act if they wish to challenge the variation. 21-day limitation. The application to the tribunal must be filed within 21 days of the date when either the written consent was provided or the special resolution was passed. Authorized representatives. Shareholders entitled to challenge the variation may appoint one or more representatives from their group to file the application on their behalf. The appointment must be done in writing. 6. Binding nature of the tribunal's decision. Once the tribunal makes a decision regarding the application, Its judgment is final and binding on all shareholders involved. This ensures that the dispute is resolved in a legally enforceable manner. No further contestation. The decision of the tribunal will be binding on both the shareholders who supported the variation and those who opposed it. This promotes certainty and finality in the variation process. 7. Filing the tribunal's order with the registrar. The company is required to comply with procedural obligations after receiving the tribunal's order. Filing requirement. The company must file a copy of the tribunal's order with the registrar of companies within 30 days from the date the order is issued. Regulatory compliance. This filing ensures transparency and legal compliance, allowing the registrar to maintain up-to-date records regarding the company's shareholding structure and the variations in shareholder rights.